Good morning, sir. My name is Stuart Catchpole. I am instructed by DAC Beachcroft on behalf of Rydon Maintenance Ltd. As you're aware from our written submissions, we don't seek any specific directions at this particular meeting. We would, however, wish to make some short, mainly responsive submissions to the matters that were addressed to you yesterday, and in particular the submissions made obviously by those representing all of those affected by this tragedy. If those submissions could be summarised shortly, and I will no doubt not do them justice, as I understand it, they were to the following effect, which is that the inquiry must be fair and must be seen to be fair. Rydon agrees. And that applies as much to those affected by the fire as to those who are also appearing in front of you and the individual witnesses who will be called to give evidence on behalf of the corporate and institutional core participants. With that introduction, I, with your permission, would seek to deal with three topics. The first is the engagement with those affected by the fire by the tribunal. And the second is disclosure, and the third is a broad ragbag of case management experts and the phase 1, phase 2 split. You were addressed, and if I may say so, eloquently and at length yesterday in relation to the desire of those who have been affected by this tragic event to have a greater interaction with the inquiry process, to have their individual and collective voices heard, and to have their concerns raised publicly, and to have those concerns considered fairly. And fair in this context, as I understand it, is in particular the need for their clients to have a reasonable confidence that the person actually, or persons actually considering their concerns, has a genuine appreciation of the circumstances in which their lives are conducted and can see things from their very diverse perspectives. To the extent that it assists, Rydon agrees. And that's not just on behalf of Rydon, the company, it's the legal team who have represented Rydon, have much experience of public inquiry work. It's fair to say almost all on behalf of institutional or corporate clients. But it is a feature, rightly or wrongly, of a number of inquiries that the victims, or a substantial body of the victims, feel as if they are disenfranchised. They feel as if they're marginalised by the process, and that the things that really touch their lives aren't given proper consideration or aren't properly understood. I say rightly or wrongly, but it is clear that's happened from the Taylor inquiry, in which I was involved back in 1989, right the way through. It is inevitable, given the range and nature of the issues with which this inquiry is concerned, that those feelings and those concerns on behalf of those affected are going to be voiced in an acute form. And we would respectfully suggest that they are real, legitimate, and however you do deal with it, they need to be addressed. You've raised with others the need for a consultative panel as an approach. We would suggest that the right way is actually interaction with those representing those affected, but anything that can be done to instill greater public confidence in the outcome must be a good thing. I would, however, note, first of all, you are unlikely to make everyone happy. Secondly, that fairness also demands that to the extent that any of those concerns are matters which are going to be raised in this forum, then proper notice needs to be given to those other core participants who might be affected by those concerns and would need to respond to them. And I will return in a moment, if I may, to some short observations on the implications for the management of the inquiry process. The second topic was disclosure, and that was split into two different aspects. The first is a call for greater transparency and scrutiny of the inquiry's disclosure process, the requests and the responses. The second is actual disclosure of documentation. In relation to the call for transparency, once again, Rydon agrees that it would be appropriate for there to be greater transparency and scrutiny of the disclosure process. It's both fair and, if properly managed, it's likely to lead to the early identification of gaps in the evidence that you will need to consider. I say, however, that it not only applies to those affected by the fire, it applies to all core participants. It goes without saying that, with respect, those represented by counsel who you heard from yesterday will be able to identify gaps in disclosure that they believe exist. My clients will be able to identify other gaps that we may think may exist in disclosure, just as others will look at, no doubt, ours in due course and say the same thing. I would add that, as you're aware, and as others have said before me on behalf of this side of the alleyway, Rydon has cooperated fully with the police and with the inquiry. And I know, sir, that you are aware in particular there's been active cooperation with your team by Rydon and its solicitors, not only to gather and provide to the inquiry all of the evidence that they wish, but to do so in a form that is comprehensible and usable. And that has been ongoing for a number of months. It's been a very substantial task. I know that, but the victims don't. And I would suggest that public confidence can only be increased if, in some manner, a procedure can be adopted to allow them to see and to test what has happened. We very much doubt that that requires all core participants, or indeed even some of them, to be involved in the nitty-gritty of drafting requests, scrutinising drafts before they go out, or things like that. It's very much a process to give confidence in what has gone on and to identify areas which you may consider are necessary to investigate further. That leads me to actual disclosure. We would have thought it almost goes without saying that, as a matter of principle, core participants should be entitled to disclosure of potentially relevant documents in sufficient time to enable a proper and informed review of that body of evidence. That is the only way they can contribute meaningfully to this inquiry process. But that is subject, we would suggest, to two caveats. The first is there was a suggestion yesterday, I believe at least, that disclosure should commence immediately by the inquiry, even if that means that it should be given in an unstructured, or I think the phrase was chaotic, fashion, because that is the inevitable consequence of an inquiry. We would strongly, very strongly, caution against unstructured or chaotic disclosure. Many of us have seen the effects of that approach in different forums, and including in public inquiries. In the VSE inquiry, for example, an approach was taken, for understandable reasons, to disclose documents almost as soon as they were received by the inquiry and someone had checked for potential relevance. It made it impossible, and I can say impossible, for anyone meaningfully to get on top of that evidence in an efficient and economic way. And I was representing one of the institutions who we're often accused of having deep pockets. For those that do not have deep pockets, it's inevitable that there will be significant wasted expenditure being sent down blind alleys, and I would suggest an inability properly to digest and assist you at the end of the day. It's not, and even putting aside, as a second aspect, the legal question of whether Article 2 requires complete disclosure of every document to every core participant, a matter on which there's plenty of law, and I've no doubt you'll have it in mind. We would suggest it is not the function of the core participants, any of us, to duplicate the inquisitorial task of the inquiry team. We are here to assist you in resolving the issues within your terms of reference. And we would suggest that disclosure to core participants has to be made in a logical and structured manner. It has to be managed in a way that is fair to all participating in this, and I fully appreciate what those affected by the fire are saying, that they do not have access to as much as anyone else, and steps need to be taken to address that. But it has to be done in a way that actually allows you, sir, to progress this inquiry in the way that you ultimately determine is appropriate, and which allows you and your team to actually do the task that you've been set. And that task, with respect, at the risk of stating the obvious, is to deal with a vast number of issues in a reasonably short period of time. And that is not a process that is amenable to however many lawyers sitting around these tables scrutinising 270,000 odd documents. It's just not a sensible way of proceeding. We will be here for years. That really leads neatly into my third general ragbag area of case management. If I may say so, there was a concern, at least on our side yesterday from some of the submissions, that we were focused on some really important issues for those affected by the fire. But with respect, we should not lose sight of the fact that at the end of the day, this inquiry will have to deal with a vast quantity of potentially relevant documentary evidence, and will have to consider multiple expert reports covering complex and possibly not particularly clear technical issues. Even if one assumes that the 270,000 documents mentioned by Mr. Millett yesterday contain an element of duplication or some which are not relevant, although hopefully that is not the case given the work the inquiry team have put into disclosure, one is certainly makes an educated guess that you are facing hundreds, possibly thousands of lever arch files of documents. And these are documents which have already been filtered for relevance. Now, reviewing, assessing and making determinations on that evidence is a very, very substantial undertaking. If you add into that the task of taking overlapping, complex expert evidence, which in itself, from experience, is a very substantial undertaking, this inquiry faces a very formidable task. And the marshalling, analysis and determination of the issues arising out of that expert evidence requires, in our submission, a particular skill set. Whether we like it or not, it is a skill set that lawyers and judges possess. That is what we are trained to do. And while we make no submissions as to whether or not the panel should be expanded, it's not appropriate for us to do so, we do suggest that one of the considerations which needs to be given proper weight in determining whether that should happen is the need for any panel member to be able to do justice to the substantial task that is faced by this inquiry. It is not an inquiry like the Taylor inquiry. That was largely about factual evidence with one technical issue, which is about a safety barrier. This is not that case. The third area of case management is the case management by the inquiry, and I hesitate to make observations on this, but we would suggest that cases of this magnitude inevitably have to be proactively managed by the tribunal. It's simply impossible for them to be effectively and fairly managed if free rein is given to any court participant to engage in the process, to cross-examine in an overlapping manner. I would respectfully suggest, but it's a matter for you, that a procedure that's akin to an inquiry procedure, where everyone gets a chance to cross-examine on multiple evidence, is unlikely to assist in actually distilling the issues. It's unlikely to assist in narrowing expert issues. It is highly likely to add to the confusion of the matter, and it is highly likely to be unfair to at least some witnesses who will receive multiple cross-examination by different parties. And that is precisely why one assumes that a decision was made to make this inquiry an inquisitorial process. And at the end of the day, as the others have said, that is what should be respected. And we are here to help you achieve that aim as best we can. That is not to say, however, that the inquiry should not receive and listen to carefully applications for specific targeted cross-examination from interested corporate. Of course they should. It's a basic premise of fairness. In terms of the expert process, I echo what has been said by many across this room. First is that the timetable that was suggested by the inquiry for the review of the inquiry's expert evidence was simply too short. It is impossible to do that job properly. Secondly, should those affected by the fire have access to expert evidence, hopefully properly marshalled and coordinated? Of course they should. Anyone who does these sorts of cases knows you need to be informed by your experts, because that's the only way you can make meaningful contributions. But hopefully properly managed, not multiple experts, limited number of course they should. Thirdly, should the process be left to disclosing the inquiry's expert reports and then inviting those who want to put their own experts forward to come in and get involved? In my submission, no. Experience suggests that many technical issues can be resolved if you are involved early enough, and if we can make suggestions through the inquiry team as to what further inquiries the inquiry experts ought to make, and to actually identify assumptions they may have made and have them tested. To that end, not only does some disclosure need to be given, but one would think that there is evidence that could be disclosed to all of us now, the video footage of the night. If there are records, as there must be, of the experts visiting the site, given we cannot, they should be disclosed. They should be uncontroversial. Photographs taken by the experts with sensitivity, for obvious reasons, should be capable of being disclosed. The ability to see any tests or forensic examinations that they are undertaking, not to participate, to observe and then feed back through the inquiry. All of those things are likely to lead to a more effective process for you at the end of the day, and are likely to lead to a narrowing of the issues. That leads into the final point on which I would wish to address you, which is phase one, phase two. Clearly, there are difficulties in the split. Clearly, there is an imperative to get on with something. We would suggest, again from our experience, that having effectively a provisional timeline of the events of the night relating to the fire, ignition and spread, and to the smoke penetration through the building, together with the evacuation, is inevitably a baseline against which this inquiry will proceed. And it shouldn't be fixed. There may be things that come up in phase two, but having that document coming out of phase one, and any recommendations that you see fit coming out of, has got to be helpful, because it focuses everyone's mind on facts which are either not controversial or identifying those facts that are controversial for the purposes of phase two. Those were my submissions. I anticipate you were going to ask me about a position statement, and our position is quite clear, and it really reflects what I've said before. Fairness demands that if people are going to be subjected to potential criticisms, then they should be given notice of it. That's the point at which they should be invited to respond. We, like other core participants, would wish, I suspect, to put in opening and closing statements on the phases, but the bottom line is that any core participant who may be subject to criticism